My name is Daniel Perrone. I have a PhD in English and law, and my dissertation actually focused on the concept of academic freedom and the law. Recently graduated. I'm an adjunct assistant professor here in the English department at John Jay College. So welcome. Thank you for joining us for this important discussion today. We're going to start looking at this concept of academic freedom and critical thinking. This will be a general primer and introduction. This isn't going to be in depth in terms of any one aspect, because academic freedom is a very wieldy topic, so to speak. It could go in a lot of different parts. But we are going to slowly go through this. Then eventually, once I go through the presentation and the basics of academic freedom, and especially related to the law, then we're going to do some fact patterns, go into breakout rooms. We'll discuss these fact patterns to analyze if it's related to academic freedom, and you'll be able to jot down your answers on a Google Classrooms document. So does anyone have any questions before we begin?
No, sounds good.
Okay, thank you very much. The first thing I'd like to discuss is academic freedom for educators, what this actually means. And here's a general guidepost while looking at this concept. Now, we talk about the concept of academic freedom. First of all, one thing to keep in mind, a professor, educator, anyone post-secondary should have the right to profess within that educator's area of expertise, so to speak. So whatever discipline you're working in, whatever you're trained in, that should be okay for you to actually speak on that subject and within any permutations related to that subject or discipline. Second, another thing that's important in relation to this, and this is actually one of the most important things to think about when you're looking at the concept of academic freedom and the concept of actual freedom within the academy, is moving the conversation, the area of expertise forward. How exactly, when you take your conversation, whatever subject you're teaching, whether in the humanities, STEM, whatever discipline it is just something that you're doing within that discipline to provide greater knowledge, to provide greater benefit? Are you moving this conversation in your discipline forward in whatever way, either indirectly or directly? Theoretically, that should give you a lot of leeway. It should give you a lot of freedom as you want to approach your discipline, as you want to query your students, as you want to utilize any tactics that you feel necessary that are useful in order for moving that discipline or sub-discipline forward. So, and that's the most important thing to look at here. It truly is a creative endeavor, irrespective whether you're in the humanities, the social sciences, the hard sciences. The way you bring that conversation forward is imperative when we look at this concept of academic freedom. Now, if you're in a public university, you have more protection theoretically than if you're in a private university. In a public university, especially within the confines of the law, since you're in a government-funded institution, you have the right to the courthouse. So in effect, what you're able to do, you have a cause of action based on freedom of speech, based on the First Amendment to the Constitution. So that's an added protection that you find here that people, unfortunately, in private universities may not necessarily have. You may have been keeping track of the news, what's been happening at some of the big private universities in the country, such as Columbia, Harvard, Brown, and whatnot. Those are private universities. They can give you, quote unquote, academic freedom, but there's no right to academic freedom, so to speak. And by the way, it usually could be contractual. If you're at a private university, usually you work with your union to have some sort of contractual right to academic freedom. But the good news being in a public university, you actually have that added benefit, so to speak, where you should actually bring a lawsuit and get into a federal court, get into a court based on a freedom of speech. So that's the good thing being at a CUNY or being at a public university. Tenure generally does provide more protection if you're at a university. So for those who are tenured, you should have more of an ability to work within your discipline and to explore your discipline in the best way you know how. So always keep that in mind that if you're in a university and you have tenure, that helps. If you're adjuncts and non-tenured, and fortunately for a lot of the profession, a large percentage of the profession here in the public and private university are adjuncts, such as myself. I'm an adjunct assistant professor here. And if you're on a non-tenure line, it's a bit more tenuous. And you still, if you're in a public university, you do have that constitutional freedom. However, there's more of a likelihood that you could be quote unquote released at will. As an at will employee, is that you don't have the same type of protections as an adjunct that you should have as a full timer. And a lot of this could be done quite indirectly. Quite simply, you'll see this a lot for educators who are dismissed. Usually, they're just not reappointed. It's just plain and simple. They usually wait until the end of the semester or the term, and they just get a reappointment note. If you've ever noticed, when you look at a lot of those notices, you'll see the fact that their assignment is contingent upon enrollment and budgetary constraints. That's usually a pretty good catch-all that administrators could use if there's another reason going on there. However, there should be something of a due process right. Even if you're in a public university and perhaps in a private university, but not as much, but in a public university, you actually should have something called a due process right, which essentially means you should have right to a notice and a hearing. So just keep in mind when you're looking at this concept of academic freedom, if you're in a public university and if there is an issue related to your scholarship, to your teaching, and there might be an issue of not being invited back, especially as an adjunct or part-timer, but especially as a full-timer, you should have a right to due process, where essentially you have to be notified by an individual at the university level of your notice, and a reason is given, quote unquote. And you should be entitled to a hearing saying why you are not allowed usually to do that. So theoretically, there should be, if you're in a public university, especially, there is a due process right that you should be afforded. Um, Even if they say it's for budgetary constraints, whatever the reason is, there is an avenue for that as well. Now, this isn't imperfect process, so just keep that as well. Um, the process itself could be flawed in terms when you look at it, generally speaking, but there is a due process right at the very least. Any questions so far?
No, not
So
yet.
we're going to do, oh, sure. Yes.
No, all I said, Daniel, was not yet. No questions yet.
Okay. Thank you. Okay. So we look at this concept of academic freedom. Um, and if we look at it in terms of the courts, I'm focusing here on the United States Supreme Court, the highest court in the land. However, there are lower courts that draw some distinctions. But looking in terms of the final arbiter, I look at the Supreme Court here. The concept of academic freedom, originally it was introduced, the concept actually started out with this concept of a marketplace of ideas, which basically was from John Stuart Mill in the 1800s. It was actually put forth in where basically the marketplace will sort out who exactly uh, the opinion, the fact pattern is that should be followed. And theoretically, you go into a town square if you're in your community, you debate the issues of the day, every viewpoint, even those that seem so far off the beaten path or that are seen as shocking, are given an airing in public. And at that way, you have people within the community who decide within the community, okay, this is the path that we want to take based upon a reasoned debate. So it comes back to this general concept of a marketplace of ideas from the 1850s and John Stuart Mill. As we go forward, the courts did pick up on this. In the early 20th century, you had Oliver Wendell Holmes, who was a bit of a wordsmith, talk about this concept of a marketplace of ideas, not actually within an educational context, educational case, though. It did start to get more credence in the 1950s, especially during the Red Scare, um, where you had people who were blacklisted, people who lost their professions based upon their political viewpoints and what they believed. So you started to see that in the 1950s. There was a case involving school teachers from the 1950s, New York City school teachers who were fired um, for being called communist, even if there was a very tenuous link to that as well, and the Supreme Court upheld that. So you started to see then, though, the dissent by Justice Douglas, was starting to go more into that concept. That's saying there actually is a concept that he used called academic freedom here, that educators need this protection. Looking at this, I'm going to go forward to 1957, the Adler case, which was 1952. By 1957, things got a little bit better. And there's a case called Sweezy versus New Hampshire. This was an educator who wanted to give a discussion related to, it was, I think you believe he was an economics professor, focusing on the concepts of marketplace, utilizing a sort of Marxist ideology in terms of the lecture that he was giving at his university. The university didn't like it, and they terminated him. In 1957, the Supreme Court said there are actually four freedoms of a university. Now, this wasn't the main opinion per se, it was in the concurrence. So even though it's not considered binding precedent, you start to see for the first time here where an actual professor was allowed to say, okay, the court said, okay, this professor, you're allowed to have this level of expertise, you're allowed to teach this, quote unquote, within your discipline. And what the court said at the concurrence was actually went into it calling the four freedoms of a university. And this was actually taken from a South African conference earlier in the decade. And what the court said, at least in the concurrence, was that a university has the ability to determine for itself on academic grounds. One, who may teach. Two, what may be taught. Three, how it should be taught. And four, who may be admitted to study. So as you're starting to get a sense a little bit now, and this is more of a university-based freedom. When the freedom for the instructor comes, we're going to see that in a bit. But this is the first time that the court, even though it's not in the majority opinion, it's in the concurrence, you start to see this concept come forth, is that universities do have this right, if you will. I would call it a fundamental right, although some might debate that. But there is a right within the university system for the actual university to have this quote unquote freedom, this intellectual type of freedom. So you started to see that there. By 1967, the tide had started to change, big time. Educators were being more cognizant of their rights here in the United States. The Constitution started to have more of a play in terms of the courts were getting more friendly to this concept, and especially with this concept of academic freedom. And this was the first time that the court actually, in the majority opinion, brought forth this concept of academic freedom. And they essentially said it is a special concern of the First Amendment. Now, this was a case, Keeshan versus Board of Regents from 1967, where essentially there were four professors who were working for the University of Buffalo in the early 1960s. That the University of Buffalo was actually a private university. In 1962, it decided to merge and become part of the State University of New York, SUNY. So what happened, there were four professors. One was an English professor named Keeshan. He was the lead plaintiff here. He actually, and the four of them had to sign essentially this document. It was under the Feinberg Law. It was basically a statement that they are not communists, nor they have never been communists. They will not commit any communist activities. Basically, a statement saying that you're going to be good and you're not going to engage in this ideology and do this. And they had to swear this oath, so to speak. These four educators said, no, we're not going to do that. And then then the university, SUNY, State University of New York, said, well, you can't be employed by us. Now, there were a few permutations in this. A few of the employers, a few of the educators were on contracts, so they were allowed to finish and work out their terms while the case was winding through the court. A few weren't reappointed. And again, you're going to find that a lot when we talk about the concept of academic freedom. A lot of educators simply aren't reappointed. It's the quietest way for an administration, if they like to go about this. That's a way that they usually like to do this, that the government will utilize that sort of concept. However, Keeshan fought this, and they sued in federal court, and it actually made it all the way to the Supreme Court in 1967. And this was a powerful decision where essentially the court, for the first time, said that educators, not the university, educators have a right to academic freedom. They actually said you have a freedom of speech right, but you also have a right as an educator, calling it essentially a special concern of the First Amendment. Important parts of the decision, including the quote, that there cannot be any straitjacket imposed on educators because it imperils the future of our nation. A very powerful statement saying that educators are the ones within this democratic lab, this democratic institution, and they have the fundamental right here to educate the citizenry, the United States of America, to bring out the best. And they need to not have any straitjackets placed on them within their disciplines to bring forth the highest form of intellect, educational rigor, analytical study, and skill. Educators remain free to inquire, study, and evaluate. This is important as well. For educators, there cannot be any limits placed on them regarding their research, what they publish, and the questions they asked related to their discipline as well. For a lot of us in disciplines, that could be I'm within English to humanities, and I've also done stuff in law as well. Irrespective of your discipline, inquiry is the key to bring forth the best for students, but for yourself as well as an educator, to go forward and to find new ways of looking at things that could benefit society. The court also said that there shall be no laws that cast the pall of orthodoxy over the classroom. This is important. Um, Here at the public university and even the private universities pride themselves on free inquiry and not having the government come into the classroom and tell an educator what they can or cannot teach, or essentially some sort of dogma. Um, that is not so much about academic freedom, that's more academic fealty. And theoretically, you find the educator the worst of education that you find in communist countries, you find in dictatorships where they don't have any freedom, where they really have to teach, if you will, very formulaic from a script, so to teach, and they have to watch their every word and phrase and what they want to teach and what their responses are. That this court found is the worst of the worst. That if you're doing that, that's just not best great for the student, not great for the educator, and not great for the United States of America to bring forth the highest ideals, the highest academic rigor. They also said that by doing this, having this academic freedom, educators can gain new maturity and understanding, and students can gain new maturity and understanding, which then goes out to the community as well. Everyone is able to benefit from this because whatever subject it is you're doing, whether in the humanities or the sciences, people get to understand and know what exactly is occurring here and how they could go forth and bring new ideas that could benefit community in the long run. And that's important here to always remember. The court talks about educators, and I think their case, they focused on the university, but they were even talking on the primary grades as well. But I think by and large, they were focusing on university study, that educators have a duty to make sure their students, their charges, have a reasoned and mature look at these different topics and understanding it as well in new ways of looking at it. Focus on the word new, not simply teaching the old ways, looking at new theories. It could be unusual theories, it could be off the beaten path, but they are related to the concept and they're to be put out there for students to gain understanding. And as the educators grow and learn, then they go forward. And then they basically, the community, become the leaders and make society better. They did mention about regulating with narrow specificity. So they did kind of leave this open, saying, okay, if for a university, for an administration, if they would like to narrow, if you will, what educators could do if there's truly something that the university finds is outside of the purview, so to speak, of the discipline or the level of expertise of the educator, they could regulate with narrow specificity. So essentially, what the court was saying in this case was that, you know what, if there truly is an issue that you feel, and you truly feel like you have to impose some limitations on the educator in what they want to teach and how they want to go about teaching their subject matter, we give you that right in a very narrow way. Now, again, the Supreme Court, a professor I once had said, the Supreme Court is good at using weasel words. They won't really break out. They're not going to really tell you too much what they mean. But you can infer when you look at narrow specificity, it has to be something truly extreme. It truly has to be something that the court itself, that the educator thinks, okay, this could create severe disruption. This could be something that could actually be highly, how can I explain this? Deleterious to the university. But again, it has to be extremely extreme. They didn't kind of define that in the opinion. But at the end of the day, though, the fact that they actually utilized the First Amendment and basically said that academic freedom, this subset, has that constitutional right was imperative. That it truly is something that educators have this right. And we still, to this day, it is still good law. So educators to this day, we do have this First Amendment freedom of speech right, academic freedom. It is a special concern of the First Amendment. Now, there are some variations on this throughout the years. The next year, there was a case um, related to academic freedom, speaking as a citizen on a matter of public concern. So this was this case where actually it was a school teacher. It was a primary school teacher, gave an editorial in a local school newspaper, and he faced disciplinary measures by his education system for doing this, saying you can't do that. And because again, they said you're a school teacher, you're not allowed to give your opinion on this matter. And again, it was published in a newspaper. The court did say in Pickering versus Board of Education in 1968 that a school teacher can speak freely about matters of educational policy and management. So that's important. So you always want to keep in mind that an educator has the ability, even if quote unquote, you are an educator, you work for the system, that doesn't mean that you are muted, that you're somehow censored, that you cannot speak in public about the issues of the education system. So for an educator at CUNY or SUNY or an institution, if you want to write an opinion piece giving your critique of the educational policy and management at the university system, you're allowed to do that, and you should not be facing repercussions for that. Because guess what? You're a citizen. You're a tax-paying citizen. You're an American. You have a right to do that. It's not even within just the realm of education. Other realms as well. You're speaking as a citizen for whatever issue it is as a matter of public concern. You cannot be censored just because you're an educator. Now, again, they look at this a little bit differently. They say it's opposed to speech purely personal interest. So essentially, when you're looking at this type of speech, um, they try to draw a bit of a distinction here as to what could be speaking as a matter of public concern. But based on this case, you should be able to give your opinion and on hot button issues of the day as a citizen. And that's important too. And we're going to talk about this at the end of the presentation, how you want to give yourself some sort of latitude. As you provide a disclaimer, you always want to note that you're a citizen speaking on a matter of public concern. That is highly important. Now, this right is not a perfect right when we talk about academic freedom. Essentially, in 2006, it does seem like this right was limited. It wasn't limited, it wasn't. So in 2006, a different Supreme Court by the year 2006, they basically talked about this concept of pursuant to official duties, limiting employee speech rights. It was a case called Garcetti versus Ceballos. This was in Los Angeles, where Los Angeles District Attorney named Ceballos um, was bringing a case. He was in charge of a case, and he was trying to get the facts from the sheriff. And I think he was interviewing the sheriff because they were going to put the sheriff on the stand. Say, okay, what happened in this case? There was a criminal matter. And the district attorney at the time, a guy named Garcetti, said, no, we want you to go forward with this. Because again, Ceballos was saying, I was listening to the sheriff, and it was basically saying, I don't believe what you're saying here. So he was basically challenging the veracity of what the sheriff was saying. There were holes in the sheriff's testimony. But the district attorney at the time said, Garcetti said, no, ignore that. We want you to go forward with the case. He got upset with that, Ceballos, and said, well, I can't do that. You're telling me something I'm telling you as an attorney, as an officer of the court, that you're telling me something that's actually, this may not be true, what the sheriff is saying. Garcetti reprimanded him. I believe he lost a promotion as a result of this, and there were a lot of issues going forward in terms of his career because he was a career employee. This went all the way to the Supreme Court. The court allowed the repercussions. The court sided with District Attorney Garcetti here, saying, no, Ceballos, you have no right to say anything in this. Essentially, it says you're limiting the decisions made by the employee. You're allowed to do that pursuant to their official duties. So essentially, if you're an employee, remember, you're working for the government, and you want to limit what an employer is saying, an employee is saying, you have a right to do that as is pursuant to their official duties. Just because you work for an organization doesn't mean that you have a right to go against whatever the supervisor may say in that organization. Even however you feel about it, there is a chain of command you have to follow. However, and the court did note this as well in the majority, that this is for customary employee speech jurisprudence. Basically, they were looking at this in terms of an employee-employer relationship in a more traditional term. Now, people might ask, what about the concept of academic freedom? If an employee, let's say an educator who works for the government, wants to go forward and say something, and they're criticized and critiqued about it, and all of a sudden their chairperson or the president of the university or the chancellor says, no, you can't teach that. If you teach that, that's insubordination, you will be terminated or have a repercussion. The court was kind of interesting the way they said that. The court was silent on the speech related to scholarship and teaching. So the court essentially said, we know there's an issue here. This was brought out in dissent, but the actual majority mentioned this, that even though that this could be seen in terms of damaging the academic freedom of an educator, we do not go forward in that case. We do not address the case on that. So what they were doing, in effect, they were limiting their analysis to just the customary employee speech jurisprudence. They were not focusing on an educator. And they made it clear in the majority as well that they do not have an analysis based on that their analysis is not based on the educator and the educator's employer. So that's just something to keep in mind because this case has been used a lot, even with of education at the lower court level. So you want to keep that in mind, that this case is out there. However, the court did clearly state this is not overturning Keeshan from 1967. They didn't say that a special concern of the First Amendment does not apply. Now, when we look at this concept of academic freedom, and we look at recent United States Supreme Court decisions that are related to this. And again, it's kind of more tangential. There was a case in 2022 called Kennedy versus Bremerton School District, where a public high school coach was praying after the game. I believe he was a football coach. He would pray on the field after the game. And the issue of there was something of an issue of the quote unquote freedom of the educator, but there were really no questions of classic academic freedom in this case. And I think they kind of said that, they did say that in the opinion, that there were no questions of that. Now, in this case, it was interesting. As they were saying, there were no issues of classic academic freedom here. When they cited the academic cases in their citation, they stated Garcetti first, and then see also Keeshan. So you're starting to wonder, again, even though they don't explicitly say that, is the court starting to gear more if a case of academic freedom was going to come up? Would they take the Garcetti route and basically just a customary employee-employer relationship and not as much focus on Keeshan if Keeshan's just on the back burner? So they didn't decide that. Something to look forward. You might want to look at in the future. Then there was a case called Students for Fair Admissions Incorporated versus the President Fellows of Harvard College from 2023. This was a race-based admissions case related to the concept of affirmative action. It focused on the concept of academic freedom, but it looked at it on a different track of academic freedom. There was a case called Bakke. It was a Supreme Court case from the 1970s that look at race-based admission and the freedom of educate of students to apply and for universities to make admissions decisions based upon the students' race, creed, ethnicity, religion, that sort of thing. So that's on a different track of academic freedom that we don't look at here. So again, it's just something in the periphery, so to speak. The final thing we want to look at when we look at the courts and academic freedom is this concept of how it's being viewed today. And I'm looking at it from the lower court using pursuant to official duties reasoning. So this was a case from 2006, Borowski versus Keene University in New Jersey. And it was a business law case. The professor was an attorney, and they were using a fact pattern. The law professor, in effect, this was in a classroom, was playing devil's advocate, so to speak, and basically talking about a case related to employment discrimination. And she was bringing up facts that where the employer did not want to hire a female who perhaps was pregnant. There were some perhaps derogatory terms made, but in the context of the fact pattern that were basically saying that this is what the employer thought of the employee in not hiring them. And then it veered into a legal argument, legal discussion. Now, the scenario that the law professor used was drawn from legal precedents and textbooks. So it wasn't as if the law professor was flying all off the handle here, which again, even within academic freedom, they're allowed to have a level of freedom to do things like that as long as it's related to their discipline. This professor actually was playing it somewhat close to the vest and utilizing legal precedent and textbooks. So it was based on utilizing fact patterns, and it was intended to provoke critical discussion. So this was something that was imperative for the educator to get forth to their students that we have to bring the conversation higher, utilizing the why and the how, higher order thinking skills to provoke a critical discussion. And the best way to do that, as educators sometimes do, they'll bring forth scenarios that are enticing, so to speak. Scenarios that bring forth conversation, discussion, high interest, so to speak, that you want the students to be involved. So you will play to the edge. You will be very out there and outlandish sometimes. But again, you keep the students engaged, and it relates back to the discipline. Some students, however, didn't see it this way. Some students found the remarks offensive and discriminatory, and they reported back to the university. The professor, who had been there for quite a few years, was terminated. Essentially, the professor was not asked back. And what the court said in this case was that they gave a broader discretion to restrict speech in the workplace when it acts in its employer's role. So they basically were saying what Garcetti said. You could speak, an employer has the ability to fire someone because the employee is pursuant to their official duties on internal personal grievances rather than matters of public concern. So there's no First Amendment protection. So what they were saying was that what this professor did in utilizing this fact pattern, utilizing the language that related to the fact pattern, that you know what, no, you don't have a right to say that. You could not be reappointed. And I think the professor was an adjunct. The professor was an adjunct. The professor did not have to be reappointed based on that, because they called this an internal personnel grievance. So they basically said they didn't even get so much to the case when you look at a free speech claim. They basically didn't even entertain the notion of how this is speech. There was not in terms of a deep analysis related to that. They said, nope, this is employer-employee relationship. And since the employer said, no, this is an issue of personal grievance and not a matter of public concern, you're gone. By the way, there was no mention of Keishan in that decision. So the case that we talked about from 1967, that wasn't overruled. It's an imperative part of the legal landscape when looking at the concept of academic freedom. There was no mention of it. So when the judge didn't even mention it there, you kind of get a sense with this judge how they might have wanted to view this and go forward in it. Because if they would have brought Keishan in, it would have involved a different type of claim. There is a concept of student academic freedom, which I'll go over a little more quickly. Students do have a right of academic freedom. Basically, it's divorced from actually or potentially disruptive conduct. So again, students do have this right of academic freedom as long as it's not disruptive. Neither students nor teachers shed their freedom of speech or expression rights at the schoolhouse gate. So essentially saying just because you're an educator or if you're a student, the Constitution does not apply just because now you enter a classroom. No, the Constitution still applies if you enter a school building. Now, students are persons possessed of fundamental rights. The court mentions that as well. This case dealt with students wearing a black armband during the Vietnam War. Students wanted to wear the black armband to protest the war at a public high school, and the school said no, you couldn't do that. But they said, no, students, you do have a right to wear that. But it goes both ways. Students can't be quote unquote overly disruptive as well. You have to respect the rules of the institution, but simply something like saying they want to protest by wearing a shirt or wearing an armband or something, the students can't be penalized for that. Another issue related to student academic freedom, student organizations. This concept is looked at in a case called Healy versus James from 1972, where a student organization during the late 60s wanted to protest the Vietnam War, and they wanted to set up something of an encampment or something of a protest they wanted to do on campus. The court sided with the protesters actually, and saying that the students can participate in the intellectual give and take of campus debates, and the impediments cannot be viewed as insubstantial. So the court was saying students do have a right to protest. You cannot just block students off to protest, and you cannot do an insubstantial impediment. Well, let's say you want to throw them into the furthest corner of the university, put them behind an enclosed gate or barrier where no one can see them. So you have to, even if you want to provide an impediment, it can't be a substantial impediment. You have to give them a little bit of leeway in order to air their grievance in the public forum on campus. Now, they did say the university has a heavy burden to demonstrate the appropriateness of the action. So the university said, no, okay, if you want to limit this demonstration, you can do it, but you have a heavy burden to say why you want to take this action. Why do you want to go forward this much in this route? So again, that's something to watch for, especially in our current times, where you talk about administrators blocking or banning protests or banning demonstrations on universities or on campus. Are they able to go that far? What's the limits they could go? By the way, as a historical overview, the government can place reasonable time, place, and manner restrictions on speech. That was a Cox versus New Hampshire. That was from 1941. So just put that in the background there. There was also a case of student academic freedom related to equal access. The case Christian Legal Society chapter of University of California versus Martinez. Essentially, students wanted to set up a student group, an affiliated student group on campus, a Christian organization, where they wanted to ban homosexuals. The university said you couldn't do that. You have to be inclusive, and you have to include all different groups within this club if you want to have it. This went up to the Supreme Court in 2010. The court said you cannot preemptively ban students from an organization. So they said to a student group, okay, you do have some cadre of speech rights, but you now can't turn around and deny others those same rights within your group. So you cannot preemptively ban students from an organization. They said, and this kind of harkens back to the language of Healy versus James, it's about the educational experience. Basically saying that for the educational experience, it needs to be open from all. All participants in the forum must provide equal access to students. So if you're a student organization, if you want to put form this forum, you have to allow academic freedom as well in a sense, and you cannot quote unquote ban students based on some sort of variable that you decide you can. And I assume that would be race, religion, ethnicity, gender, sexual orientation, that sort of thing. That concludes the main part of the academic aspect of this. And my question is to all of you, what have we learned today? So what we're going to do, does anyone have any questions right now, by the way, before we go on and look at the fact patterns? Okay. Well, we're going to do, we're going to look at one of the fact patterns. I'll read it to you. And what we'll do, we'll break off into groups. Um, and we might not have time to work on all of them. So I want to work on a few of them. And we're going to look at a professor's work blog assignment. So I'm going to read the fact pattern and you could break off into groups and you'll work on this in Google Classroom's doc. You can work on this a little bit. So let me read this to you. So this is fact pattern 2. A professor is giving a work blog assignment. So Professor Emmanuel Goldstein, a writing fellow in the Writing Across the Curriculum WAC program at Oceana Federal University, submitted a blog post as part of his required work for the program. The post was titled, "To End the Inner Party and for a Free Brotherhood. How do we do very effective writing?" 3 days after the blog was posted, Professor Goldstein reported to the coordinators of the Writing Across the Curriculum program that the post had been removed from Oceana FU website and that the blog itself had become password protected. He was informed by a coordinator of the Writing Curriculum program that your recent blog post was taken down as it was outside the scope of content specified for blog posts in the WAC Fellows Handbook, adding, "This decision was made by college administration. Please reach out to Provost Tom Parsons, CC'd on this email, if you have any questions." The guidelines provided for WAC fellows regarding their required blog posts state, possible topics include previous upcoming workshops, general WAC principles, teaching writing in the classroom, and sample lessons. Professor Goldstein's post, in fact, addressed several of these topics quite directly. The post is similar in content and form to many others that have been previously posted by WAC fellows on the site, which deal with topics such as the political economy of WAC writing practice, the stress involved in writing a dissertation, and the institutional structure of the WAC program itself. The flexibility and open-endedness built into the WAC guidelines is in keeping with the principles of writing across the curriculum and of writing pedagogy more generally. There is no indication that such posts are ordinarily vetted in this way by the provost or others in Oceana FU's management. Is the removal of the blog a violation of Professor Goldstein's academic freedom? So what we will do now for a few minutes, I'm going to break you off into groups. And I also have a link that I included in the chat. I'll show it to you now. And this is the second one, fact pattern, where hopefully you'll be able to work on this a little bit as we go over this. I'm doing it. So what I want to do as we get this, and I see we have 6, so we could do probably 2 breakout rooms. And what we'll do, we'll go into the rooms and basically you could work on this for a few minutes and discuss and write your answers on the Google document. So again, does anyone have an issue getting access to the Google Drive document? Okay, so I'm going to create the breakout rooms now. We'll be back. Give it a few minutes, maybe 5, 6 minutes, and you can look at this fact pattern and tell me what you think. And if you have questions, let me know. I might bounce around from room to room.
I just want to give you a heads up, Dan, that we're closing in on the 10 o'clock. Not trying to cut anything off. I just wanted to let you know that we're getting close to that time frame.
Okay, thanks. So we'll make this
Sorry,
kind of short, maybe 4 or 5 minutes. No, thank you.
Okay.
Okay, let me do this now. Okay, thank you.